Mr Chair.
The Honourable Maggie Barry.
Thank you, Mr Chair. I rise to speak to the Wildlife Powers Amendment Bill at its committee stage with great pleasure. Before I address the SOP, which has been preoccupying some of the members in this House, I will reaffirm that this is a primary piece of legislation empowering the Department of Conservation to do something very specific indeed, and that is to protect vulnerable native species. This is not about mallard ducks. This is not about black swans. It is not about the kind of work that the fish and game rangers, voluntary or full-time, do as their core business. This is about vulnerable endangered species that smugglers and others could take away with them. So we're very clear on the purpose of this bill. It is an old piece of ledge, no longer fit for modern purpose. So we have carefully thought through and targeted a sensible upgrade and expansion of the powers given to DOC. And in addition to that, fish and game full-time rangers will also have an additional power. So to quickly recap, DOC rangers are currently not able to intervene to prevent offences taking place or about to take place should they come upon them. That is foolish. So we've tidied that up. Section 39C now allows them to take action, quote, in a manner that is reasonable in the circumstances to do so. Second, rangers are currently authorised to stop and search vehicles, vessels and bags and other items in transport, but they cannot stop people from leaving the scene of a suspected offence to ensure that they have enough time to gather evidence and take details. Part 39B of the amendment bill addresses this aspect. The third one is that the Act currently allows rangers to seize only a few types of evidence. Again, this is proving the old-fashioned nature of the era in which this bill was originally conceived. So it doesn't include modern technology such as mobile phones and computers, which are of course vital sources of information in modern investigations. Section 39A of the amendment bill empowers them, quote, to seize any evidential material defined in the Search and Surveillance Act 2012. And finally, establishing and verifying an offender's identity is essential to any ability to prosecute. Now, that is true, and as it stands, the Act allows rangers to require a name and address, but there's no provision to provide further proof of identity. So that is a loophole. Under Section 66 of the bill, DOC rangers will be able to require date of birth, name and address, and this power will also be extended to full-time fish and game officers. So they're getting additional powers that they didn't have before, but that power has not been extended to voluntary fish and game officers, nor has it been extended to voluntary DOC rangers or to voluntary police, fisheries or defence rangers, because these people are voluntary. They are not signed on to a code of conduct as other public servants are, nor is there any accountability. So if they don't do the right thing, we are not able to come back at them. This is a very important distinction, and it is the reason why we are not, as a government, supporting the SOP from Mr Parker. I'm a bit surprised at his SOP, actually. It could have gone further than it did, but as it happens, it just wants to get voluntary fish and game officers or rangers to be able to have the same ability to require that they can ask for the date of birth, because at the moment they cannot. And the bill's very clear on this. Honorary fish and game rangers, honorary fishing officers or rangers appointed under Section 38(2) can ask for someone's full name and residential address, not their date of birth. What we have done with this is that we have said that fish and game rangers are able to give and require a person to give their full name, their residential address and their date of birth. So when you look at the penalties for what happens under this Act, 67F Clause 5. This is under the Wildlife Act of 1953, and I have brought it down if anyone wants to take a closer look at it. But what it says is that in the case if someone refuses to give their date of birth, refuses to supply their date of birth to the fish and game ranger, the penalties are substantial. And this is harking back actually to my friend and colleague Jackie Dean's bill, because the penalties have been greatly increased. So in the case of an individual who does not give their date of birth, they are liable for a term of imprisonment not exceeding 1 year, or a fine not exceeding $100,000, or both. In the case of a body corporate not giving the information about date of birth, there will be a fine not exceeding $200,000. So, Mr. Chair.
The Honourable Maggie Berry.
So, Mr. Parker, I understand, is a lawyer, so I would have expected him to go back and check his facts. That he has not done. It is very important that this House and that others who support and understand the purpose of this bill, which is to protect our native taonga species, not to protect ducks and swans and other game birds, it's very much in DOC's core business to be able to do the work that they're doing under these powers. But we acknowledge that the work of the Fish and Game full-time rangers is very good. There are some 52 of them. There are 222 honorary fish and game people. We felt that by giving those extra powers to those 52 full-time paid staff from Fish and Game, that they would be getting an extra amount of power that they have not already got, and that is to ask for the date of birth. And the follow-through from that is the penalties. If you don't give a date of birth, that is serious under the Act, because it has been required under the Wildlife Act. So these are the sort of details that really do need to be well understood. And it's disappointing that neither the opposition, nor the Greens, nor New Zealand First have bothered to actually look into the detail of the penalties, because that is a very important element of this. If you are, for example, shooting game birds without a permit or a licence, you are in some trouble. But you are not in $100,000 worth of trouble, nor are you liable to a term in prison not exceeding 1 year. These are the important provisions that we have given Fish and Game rangers because we think that they are trustworthy, they do a good job, and that's an excellent thing. But this is not their core business. They are about an entirely different set of species. And while I'm on the business of not core business, under the Wildlife Act, as you know, fresh fish of native varieties don't come in, nor do they under the Conservation Act. So that member was speaking outside the scope of what is in fact a very narrow amendment to the Wildlife Act. And the powers that we have given, I think, will do a great deal to protect our very threatened precious wildlife. And we are not so much concerned in this piece of legislation with game birds or bird hunters, and I think it is very important that the opposition acknowledge and understand that, because this is very carefully targeted. I've said that from the start. I commend the Select Committee under the very able chairmanship of my friend and colleague Scott Simpson for leading the Select Committee through this process. It is complicated, but only because it is very narrow in its scope and needs to be read in conjunction with the Wildlife Act in its original form and with Jackie Dean's, because otherwise it is not well understood that the penalties are very big indeed. And it has also been pointed out to me by some that we do need to be very careful around the powers that we give volunteers. We do not want to be giving people the capacity to arrest or stop or search and keep, because these are not trained people who are able to do that within the confines of their mandate. And I don't believe we should extend that out. David Parker, in his call earlier before the dinner break on this very bill, said that he acknowledged that those powers were not needed to be expanded, and we are in absolute agreement with that. So on that uplifting note, I will conclude my call, but again, I commend this in all its various forms and with the level of intellectual rigour and scrutiny that the Select Committee gave to it, if not the opposition members of that Select Committee, who were apparently missing in action when it came to the detail. And they lack intellectual rigour. What they do not lack is the braying and the nonsense and the capacity to just yap on about things that are not factually correct. So I'm very keen indeed to give credit where it's due, and that is to the government members of the Select Committee, who I think did a tremendous job. Thank you, Mr. Chair.
Members.